Good afternoon, everyone. My presentation today is going to be on workplace discrimination. Discrimination can come in all types. You can be discriminated against due to your age or a disability, equal pay or compensation, genetic information, harassment, national origin, pregnancy, religion, retaliation, sex, or sexual harassment. There are several laws that are enforced by the Equal Employment Opportunity Commission: the Civil Rights Act of 1964, the Pregnancy Discrimination Act, the Equal Pay Act of 1963, the Age Discrimination Act of 1967, the Americans with Disabilities Act of 1990, the Genetic Information Non-Discrimination Act of 2008. For the purposes of my presentation today, my focus will be to discuss discrimination due to age, race, and disability. The Age Discrimination in Employment Act of 1967 deemed it unlawful for employers to commit any of the following. First off, the Act protects workers 40 years of age or older. They cannot fail or refuse to hire people who are 40 years of age or older, limitation, segregation, or classification of employees in a way that could adversely affect them due to their age, reduce the employee's wage rate, limit or expel older workers from union memberships, or reduce or eliminate employee pension plan contributions simply due to their age. Age discrimination in the news. Two female employees at The Ohio State University were forced into early retirement when a new boss came on staff and started making derogatory comments and sending emails to others within the organization. These emails included remarks like, "People over 50 are like herding hippos. They are deadwood, millstones." They also lost their workspaces and took substantial pay cuts. The two ladies filed a lawsuit that took more than 4 years to come to resolution. The Ohio State University ultimately settled and were required to pay the women back pay, retroactive benefits, and all legal fees. They were also forced to rehire the ladies. This judgment came in November of 2018. The Civil Rights Act of 1964 actually covers a multitude of things. This act protects workers from discrimination due to race, color, religion, sex, or national origin. For my presentation today, I will be focusing on racial discrimination. You cannot refuse to hire someone due to their race. You cannot limit, segregate, or classify employees that would deprive them of opportunities due to their race. You cannot refuse or remove an employee from a union membership due to their race. And wages or compensation cannot be limited due to race. Racial discrimination in the news. Black workers at a UPS facility in Ohio faced decades of racial hostility. 19 workers at a UPS distribution center are suing management, claiming that they enabled, tolerated, and purposefully promoted and encouraged a culture of racism and racially discriminatory conduct. The employees faced a hostile work environment from white employees constantly being ridiculed, laughed at, taunted. In 2016, one worker made 2 nooses and hung them above the desk of an African American employee. Unfortunately, this case resulted in the EEOC choosing not to pursue charges, and instead, they enacted an agreement with UPS that provided no compensation to the plaintiffs and required no admission of guilt by the company. This is an extremely unfortunate situation. The Americans with Disabilities Act of 1990 simply states, "No covered entity shall discriminate against a qualified individual on the basis of disability in regard to job application procedures, the hiring, advancement, or discharge of employees, employee compensations, job training, and other terms, conditions, and privilege of employment. Disability discrimination in the news. A jury in Wisconsin awarded $13 million of compensatory and punitive damages to a former Chuck E. Cheese employee. The jury found that Chuck E. Cheese violated employment provisions of the ADA by discriminating against Donald Perkle due to his disability of mental retardation. Chuck E. Cheese even attempted the argument that it was highly unlikely that Perkle experienced any significant distress due to this because of his disability. That tactic did not work. Under Title I of the ADA, it states that employers must make reasonable accommodation for workers with disabilities. Chuck E. Cheese failed to do so and were required to pay substantial compensation to Perkle. This concludes my presentation today. I look forward to everyone's comments and questions, and thank you for viewing.